Thank you very much to the Max Weber programme and the UI more generally for inviting me here, and thank you very much to those who have accommodated my wish to come here in mid to late November, which isn't necessarily when your Max Weber lecturers are probably queuing up to come in the spring, aren't they? I wanted to come this week because it allows me to make one trip here and also be at the UDO conference, which is taking place, UDO Dissemination Conference, which is taking place over the next 2 days as well, which I'm looking forward to as well. So I'm going to present a version of a piece, it's really a work in progress called Citizenship as a Space of Law, the case of the new states of Southeast Europe, and that's the states that I'm talking about. These are the states that are now in the territory of what was the former Yugoslavia, and I'm going to be talking about their citizenship regimes. But first of all, I'm going to introduce the approach somewhat. So citizenship has been claimed by many disciplines. You'll have read that in my abstract. It can be seen from a legal perspective as the formal bond between an individual and a state, or indeed a non-state entity such as a supranational association of states or a subnational entity within a state. From a political theory perspective, citizenship is paradigmatically about the claims of individuals and groups to political membership of a given polity. In Arendtian terms, it's about the right to have rights and to be part of the constituent power. Although liberals, communitarians and critical theorists might disagree about how broadly this power should be defined and what specific rights should attach to being part of it. Sociologically speaking, citizenship is a membership space within a given society or community, filled out and given content through the interplay of multiple social and economic relations, especially those involving social and economic power. Geography and history, meanwhile, remind us that citizenship and citizens are to be located in space and in time, and historians in particular will debate the trajectory of membership statuses and rights. Finally, the tools of economics allow us to question to what extent citizenship may be a tradable market good rather than a pure status good where market precepts have limited or no application. Yet, despite the extent and variety of the attention given to it, or perhaps because of this, citizenship remains in large measure a black box, frequently uninvoked but less frequently unpacked. Now, one dimension of citizenship, I would argue, that suffered greater neglect than most in the literature, and that's the rich relationship between citizenship and law. Legal norms, legal institutions and actors who invoke or engage with these norms and institutions. Most scholarship, including legal scholarship, tends to assume that there are really just two dimensions to citizenship's relationship with law. The first is the formal bond, the legal status of citizenship, or nationality as it's so often called. Here the relationship to the state is almost always given the most prominence, although it's increasingly acknowledged that there can also be citizen-like, or one might say citizen-light, as Jotka has it, legal bonds between individuals and non-state entities, such as the EU. And indeed, of course, as I said before, with subnational entities within states, and indeed other territorially and non-territorially defined entities, such as regions, minorities, groups, or diasporas. The second dimension of law and citizenship concerns the role of legal and administrative instruments and processes which both give meaning and form to that status and its acquisition and loss, citizenship laws, and which fill it out through the articulation of membership rights and obligations and non-citizen rights and obligations. So citizens and non-citizens. This would tend to suggest that if citizenship is broken down into any of the various familiar triptychs of status, rights and identity, rights, access, belonging, then law is likely to have little to say about the third, perhaps most intangible domain of citizenship, that of identity or belonging. This seems to me to be a reductionist view, which focuses on law's constitutive and instrumental roles at the expense of its normative and symbolic dimension. Another way of putting this is to argue, adopting Jürgen Habermas's conception of a double coding of citizenship, marrying together the role of the state and the nation, that law should not be seen as somehow confined merely to the formal realm of the legal status itself or the civil, political and social rights conferred by the state or non-state entity, but it should also be seen as contributing to the informal and ideational role of citizenship in binding together different sorts of culturally defined communities. This is important not least because issues of identity formation often have an institutional as well as an ideational dimension. In other words, you cannot separate the two. Indeed, it can be argued that citizenship instantiates a set of institutionally embedded social practices, and I'm quoting there from Margaret Summers. And indeed, Margaret Summers goes on to define citizenship, drawing on Polanyi, as an instituted process. And it's the attempt to explore the citizenship law interface in this paper, which offers a closer look at those sorts of processes and practices, treating them as both instrumental and ideational in character. This approach to the role of law in relation to citizenship also incorporates a significant actor-centred dimension, emphasising that if indeed law is a regulatory instrument, then it is also one which depends for its effectiveness upon the agency of a certain number of actors, including individuals, groups, and formal and informal institutions in the public and private sectors. Law's effective force is often highly contingent upon the agency of these actors, and in turn the interactions between these actors, especially individuals and groups, can be mutually constitutive not only of the effectiveness of legal provisions, but also of how they are perceived as supporting or undermining specific notions of identity, and thus of citizenship. All of this presupposes, I would argue, that we need to take a critical rather than a positivist review of the role of law in relation to legal status. Citizenship laws are often treated as static sources of norms, with trend spotting confined to the area of policy trends rather than trends in legal regulation. Taking the citizenship law interface seriously allows us to review whether there is a trend towards a more intensive regulation of the field of citizenship as legal status, and to provide an interpretation of the legal and normative character of that regulation. If it remains true, as many have argued, that citizenship regulation is one of the last bastions of national sovereign discretion, a discretion that has traditionally been held onto by the national executive, increasing trends towards detailed legislative regulation as opposed to executive discretion, and towards judicial oversight of both the regulatory function and form and the residual executive discretion, are ones that need to be observed and critiqued. In other words, I think that we need to take another look at what we mean by law in relation to citizenship, and we need to take into account those sorts of questions. Citizenship law is both instrumental, but it's also ideation. So in this lecture, moving on to studying citizenship as a space of law in Southeast Europe, what I'm going to do is to argue that a useful way of unpacking the black box of citizenship as regards the role of law in relation to citizenship is to think about citizenship as a space of law across which various tensions are in play. And the limited goal of my lecture today is to map out this space, elaborating on 12 reference points across which these tensions play in various combinations. And I should say at this stage, as I think many of you here probably know, that this, the work on which this is based is, derives from my ERC project, CITSI, or Citizenship, the Europeanization of citizenship in the successor states of the former Yugoslavia, or as we often shorten it, citizenship in Southeast Europe. And the first slide had a couple of web pages there which you can find us on. CITSI has allowed us to map out the citizenship regimes of these new states, and one of the mappers is actually in this room today, there are many mappers, but we're also now looking at it conceptually and comparatively, and my contribution is to think about a conceptual framework for thinking about comparative citizenship studies, which takes a more critical perspective on the notion of law and looks at issues around intensity of regulation, type of regulation, but also, as I'll explain, as we move forward through the lecture. Also about regulation, these constellations that Rainer Bauberg also talks about, the relationships between the citizenship regimes. Now, I just should explain the genesis of the figure, because there's a few people in this room that might have seen this figure in an earlier emanation. It started out as a simple matrix with... Does this have a light? Yeah, there we go. It started out as a simple matrix with the x and the y axes, with conceptions of the rule of law, their thickness or thinness on the x-axis, and the sources of key norms relating to citizenship as a legal status and a set of rights and practices, external or internal, along the y-axis. But as my thinking has progressed, it's become clear that understanding the different elements of citizenship as a space of law requires both a more significant number of variables to be taken into account, such as territoriality, the character of norms, and some sense of the difference that a more actor-centred approach would make. Moreover, explaining citizenship in terms of a space of law also demands a subtler approach to the relationship between the variables. So originally I had just a set of lines, crisscrossing, and I just removed them all together. I might replace them with something very complicated, or I might do something completely different. But this, you know, in the true spirit of work in progress, this is the state, the very formless state that we've got at the moment. So I originally had them acting across citizenship as a space of law, but now I've reconceptualized it within citizenship as a space of law. So I originally conceptualized the different variables as exogenous dimensions acting across citizenship, but now my preferred diagrammatic representation has the variables operating within this space, co-constituting the space. And finally, I've abandoned the erroneous attempt to plot the key issues as a set of linear relationships or tensions between the most obviously interrelated variables. It may be possible to conceive different conceptions of the rule of law as operating on a one-dimensional axis, but it's equally important to take into account when understanding the rule of law and its impact upon conceptions of citizenship, not only its relationship to sources of norms, but also the territorial dimension of normative order and the degree of uniformity or differentiation across territories as well as norms. And that's just an example. Now, this idea of citizenship as a space of law isn't an approach which somehow purports finally to resolve the many contestations which mark all the rich debates about the notion of citizenship. But it does provide a deeper articulation of the mutable relationship between citizenship and law, as well as setting it in its specific historical, geographical, and political context. And in order to express that really well, I've put it on top of the slide like that. I was proud of that. I'm not very techie, but I was really quite proud. My inner nerd came out. So to pursue the metaphor, the space is also something that can be filled out with empirical detail over time. But there's no claim to universal applicability made on behalf of this approach. And in common with all frameworks for undertaking interpretative comparative legal studies, that is, those that seek to explain the world around us rather than merely to state that X is like or unlike Y, it depends for its effectiveness on a rich understanding of the lived-in character of legal institutions, legal norms and actors who engage with law. For while this articulation of how best to understand citizenship through legal lenses is not a methodology in the strict social science sense of the word, it is based on a set of underlying assumptions about law and legal regulation which are methodological in character. I've already referred to these. Law is not a passive corpus of rules to be explored as a set of yes or no answers. On the contrary, law is more than law in the books. And when considering legal perspectives on citizenship, we also need to look at the social and political context of legal regulations or legal rights, and incorporate also the ways that actors use law as part of a set of argumentative resources into our understanding. The context for developing this is, as I said, the search for an effective basis for comparison of citizenship regimes in a particular context, namely the new states of Southeast Europe, to be found in the same geographical territory previously occupied by the Socialist Federal Republic of Yugoslavia. Yugoslavia began to disintegrate in 1991 with the secession of Slovenia and Croatia, followed soon after by Bosnia and Herzegovina and by Macedonia, or the former Yugoslav Republic of Macedonia, if some of you prefer, in 1992. And this process of disintegration was completed by the declaration of independence of Montenegro from the successor Federal Republic of Yugoslavia, or more specifically by then the State Union of Serbia and Montenegro, leaving Serbia on its own by default, and finally the unilateral and contested secession of Kosovo from Serbia in 2008. For the first time breaking up one of the republics of the S-Fragi, Socialist Federal Republic of Yugoslavia, as constituted since the Second World War. From the moment of independence onwards, each of these new states created a new citizenship regime, although in all cases apart from Kosovo, the new regime depended to some extent on the prior Republican citizenship regime and on the Republican registers of citizens which existed in the S-Fragi. The importance of working with this case study can partly be explained by the fact that the region, which the European Commission now calls the Western Balkans, and which comprises all the former Yugoslavia minus Slovenia plus Albania, is an enclave within the European Union, and it is an arena of enduring and political and constitutional instability, encompassing some weak states which are uniquely proximate to the EU itself. For much of the 1990s, the dissolution of Yugoslavia represented one of the most difficult foreign policy challenges for the EU and its member states, a challenge which, in the view of many, both the EU and its member states failed rather comprehensively. Even now, while officially all of the states are at least potential EU member states, with Croatia on the verge of joining, it's hard to discern whether this region is an arena of EU enlargement policy or an arena of foreign policy. Until the Citizenship project on which this lecture is based came along, little attention was paid to the development of the new citizenship regimes which resulted from the creation of the new states. And the aim of Citizenship's research has been to remind scholars that the Yugoslav crisis, disintegration and war, as well as the current functioning of the new and old Balkan states and the process of their integration into the European Union, cannot be fully comprehended without a deeper understanding of their citizenship regimes. It also aims fully to integrate the particularities of the post-Yugoslav constellation into the field of comparative citizenship studies, while simultaneously making a contribution to how these regimes can most usefully be studied. In an era where a number of other processes of state disintegration, consensual or not, are under contemplation just in Europe, never mind the rest of the world, such a case study also has wider resonance, and I recently applied my understanding of the Yugoslav case to write a little piece about citizenship, Scottish citizenship in the event of independence, and that was quite fun. In sum, exploring citizenship as a space of law in the context of the citizenship regimes of the new states of Southeast Europe allows us critically to probe a number of key features of these emergent citizenship regimes, properties which they share in some cases with most, if not all, citizenship regimes, problems of dual citizenship, problems of diasporas, which in other cases are typical of states which are post-partition, particularly the issue of diasporas, post-transition and post-conflict, and some specific issues around the Republican registers as well. Self-evidently, a citizenship regime must be a space where legal norms apply, but in states in transition where the rule of law the values of the rule of law are contested, and state institutions are relatively weakly constituted and consolidated, questions arise as to the tensions within which this space of law is constructed. These particular characteristics of the rule of law and thus its role are given close attention in what follows. What I'm going to do now is to talk a little bit more about the notion of citizenship regimes. I've used that term a lot already. But in a way, citizenship regime is a way of breaking down the sort of the traditional headline stories of citizenship. It's the purposes of citizenship, laws around consanguinity, generational continuity, around affiliation and affinity, and the way in which that then comes into problems of the degree of inclusion and the degree of exclusion. And in working in CITSE, we've been using the analytical device of the citizenship regime in order to prise open the black box of citizenship, which for me offers a way to explain the complexity of law's role in relation to citizenship. But it goes beyond it, a narrow legal conception, and consequently it's also useful in an interdisciplinary context where other scholars are coming at this from a sociological or anthropological perspective, or from the perspective of political science and looking at the role of political elites and their calculations about citizenship laws and manipulation of citizenship laws, which is one stream of work that we've had also within CITSE. It also allows us to focus on issues around minorities, on issues around gender, all of which are topics which are being pursued by fellows who are working within the team at the moment. So citizenship regime as an analytical construct captures both the relational and institutional elements of citizenship. And as such, it offers, I would argue, a useful framework for understanding citizenship rights, their expansion and depletion, their formal and substantial existence, as well as their uneven distribution in contemporary societies. A citizenship regime comprises the citizenship laws, regulations and administrative practices regarding citizenship status, including existing mechanisms of political participation. It's based on a given country's citizenship legislation defining the body of citizens, who is entitled to citizenship and the rights and duties attached to that status, on administrative policies in dealing with citizenship matters and the status of individuals, citizens and non-citizens alike, and finally on the official and unofficial dynamic of political participation. I argued in an earlier paper with Igor Stix, the concept encompasses a range of different legal statuses viewed in their wider political context, which are central to the exercise of civil rights, political membership, and in many cases, full socio-economic membership on the territory. Citizenship regime is a useful device to combine the two main ways in which the idea of citizenship is coded, as I referred earlier, with the different articulations of the membership bond. Citizenship as legal status and citizenship as community bond. It aligns the study of citizenship with a broader literature from international relations which uses the concept of regime in order to capture patterns of behaviour, bringing together principles, rules and norms and decision-making procedures. But within the field of comparative politics, studying citizenship as a regime adopts also an approach drawn from gender studies, where scholars use the term gender regime in order to refer to the range of institutionalized practices relating to how gender issues are regulated in a given society, acknowledging that these differ from state to state. So Jane Jensen, for example, has widely used this concept of gender regime and then brought it into citizenship studies, defines a citizenship regime as the institutional arrangements, rules and understandings that guide and shape concurrent policy decisions and expenditure of states, problem definitions by states and citizens, and claims making by citizens. And it's that actor-centred dimension that I think is often missing in the study of citizenship law. I'll cut some of the material there because it really just goes on to explain one or two examples in relation to citizenship regimes. But just to summarise, that the citizenship regime is constituted and conditioned by a specific legal setup that includes not only citizenship laws and international conventions and norms, but laws and regulations on public activities. Citizens at home or in flux are determined in their actions by their status and the attached rights, as well as by legal straitjackets that constrain and condition the practice of citizenship. This influences their social and political struggles, but on the other hand, it is only through those struggles, as the history of citizenship shows, that citizenship regimes change over time. So what then are the constitutive tensions of citizenship regimes understood as a space of law? Why pick out the 12 items that are on this slide, or the originally 6 relations that were on this slide, but the 12 items? To my mind, in the context of the former Yugoslavia, a better understanding of the role of the rule of law, and therefore the concept of law that underpins the rule of law, is fundamental to understanding the character of the citizenship regimes that are in play. Since the breakup of Yugoslavia, these states have experienced a superfluity of law, illustrated by the many citizenship regimes resulting from successive state disintegrations, plus the interventions of many different international organisations and regimes, where intervention has been both voluntary and involuntary in character. More generally, they've often had to introduce a lot of new law and revise many legal processes as they've sought to align with the demands of the EU in incorporating the so-called acquis. But there exists something of a gap between the rule of law, as understood in a jurisprudential sense, and what might be regarded as the development-related industry of the rule of lawyers, which now seems to be an indispensable element of every international intervention to support the development of new states or states in transition, or states with lower income levels or lacking democratic institutions or human rights protections. The rule of law, in that sense, has become part of the foreign policy armoury of the so-called Western states, and also of the EU itself as a non-state international actor. And it's in this sense that it's been experienced as part of international intervention and as an instrument of compliance, voluntary or otherwise, with lauded international standards such as accession to the ECHR by the new states of Southeast Europe since 1991. In the process of study, despite the plethora of contributions, often more heat than light has been shed. It's at least in part as a result, as a reaction to the challenges posed by the puzzling and protean concept of the rule of law that I've tried to evolve this method of breaking down the idea of citizenship through the identification of the different types of constitutive tensions between the different elements. And so in this context, I am still going to rely upon the binaries, even though this is in a process of development. And the first binary is that between thick and thin conceptions of the rule of law. Now, in rule of law talk, the distinction between thin and thick conceptions of the rule of law generally focuses on the distinction between thin institutional conceptions and thicker substantive ones. And I'm grateful in that context to Martin Pridgier for his work. He, though, defends a middle ground when defining the what of the rule of law, remarking that thin conceptions are often too spare to amount to much, and thick conceptions are too rich to allow one to sustain any useful distinction between the rule of law, whatever else you might like to find in a society. The aim of my paper, though, is very much not to promote a single consensual definition of the rule of law, but to identify how tensions across the rule of law might play into the construction of citizenship. One issue might be around the constitutional definition of the citizenry, and we can talk about this in the former Yugoslavia and changes that have been made, for example, to the Croatian constitution when it was originally established, or changes to the Macedonian constitution after the Ohrid Accords were negotiated at the beginning of this century. And of course we can talk about a recent example as well in the wider sphere of Central and Eastern Europe, the changes to the Hungarian constitution that are very much a live issue within the European Union at the moment. There's also in that context constitutional definitions which have been brought in through external interventions, such as the Dayton definitions of communities that have been brought into the Bosnian-Herzegovina constitution, and which sit ill with the requirements of equality as instantiated in the European Convention on Human Rights, and the Sejdic and Finzi case before the Court of Human Rights demonstrated this. So there are many examples of how the citizenship regimes as constituted through the citizenship definition have changed over time. Croatia, the relationship between the constitutional definition, the legislative framework, which has changed relatively little, and the politics of citizenship in Croatia, which has changed a great deal. doubtless is changing as we speak as a result of the decision of the ICTY appeal chamber last week. Macedonia, before and after Ohrid, changed its definition of what constituted the constitutive people, the pouvoir constituant. Serbia has seen increased ethnification, whereas this was used in different ways over time. Montenegro is a good example of the meaning of citizenship law only emerging from a reading of wider non-constitutional materials by looking at the role of political elites, political parties. Slovenia, the direction of challenge has been from civic to ethnic. Also, many changes came after the 1991 constitution, but then we saw the erasure of certain groups within Slovenia who were removed from all population registers and simply erased as an act of citizenship construction. In Kosovo, we have theoretically a pure civic constitution, but nonetheless we have in practice the domination of a single ethnic group and a minority, which is, of course, poses many troubling problems for Kosovo in terms of the refusal of many Serbs to accept the authority of Kosovo and to buy into its documentation, although recent evidence seems to indicate that Serbs are in fact buying into Kosovan documentation. So there we see the interplay between citizenship and constitution. A closely related second tension is between the citizenship as legal status and citizenship as community bond, which takes us right back to some of the comments I made at the very beginning. And in this context, it was interesting to see, even under the Socialist Federal Republic of Yugoslavia, there was passport differentiation. So depending upon which republic you belong to, and one of the problems was that the registries were never kept up to date, you've got a slightly different type of passport with different languages on it and different reference to your Republican citizenship in the context of your federal Yugoslav citizenship. Albanians in Macedonia have posed the challenge of a consociational citizenship. How can you maintain a community bond in the context of a consociational challenge, which leads to many veto points and persistent low-level conflict between the majority community and the minority community? The Roma right across the former Yugoslavia have particular citizenship and status-related issues. They've typically found it much more difficult to become registered and to acquire passports, and then if they move to another state or if the state changes around them, they often find themselves reverted to zero and to have no legal status anymore and no passport. There are persistent issues of kin minorities, and kin minorities are is a notion which has probably entered many people's familiarity through the post-1989 Hungarian political actions and now constitutional changes. But kin minorities are a very significant issue, obviously, in the former Yugoslavia. You have a very large number of external citizens of Croatia who are presumably about to become citizens of the European Union, who are resident in Bosnia. Or so we think. It's difficult to tell because there are probably more Bosnians who hold Croatian passports than there are Croats left in Bosnia, so something's gone slightly wrong there. There are not only kin minorities, but there are so-called perceived kin. There's much smaller minorities, perceived co-ethnics, who raise some problems, and one of my research fellows is going to be studying that issue this year. And then there are persistent problems around censuses. When one of the typical arrangements to discover who your citizens are and what their character is to conduct a census. And census politics has been one of the biggest questions in the former Yugoslavia. Now, what can we say then about the relationship between unity and differentiation, the territorial dimension? So one of the binary tensions that was on my original chart, but is now rendered less comprehensible, I'm afraid. Citizenship's unitary status is as an ideal, as a set of practices and a set of normative ideals, and it's often challenged, of course, in practice by minorities or national status, but also by territorial differentiation. Now, that may not be a particularly bad thing in inverted commas, but it nonetheless poses challenges, and you find that not only, for example, in somewhere like Bosnia, where you've got not only Bosnian citizenship, but also entity citizenship, and then you have a very peculiar status for those who are resident in Brčko, which is a sort of out with both of the entities, and it's arguable that they don't have the proper voting rights that they should do because of the interaction between their status and the Dayton Constitution. But it poses similar challenges in lots of other states where there is devolution. So in the UK, there are issues around territorial differentiation and policy choices in the UK, particularly between Scotland and the rest of the UK, but also Wales and Northern Ireland in certain respects. So that's nothing particularly new, but in the context where tensions are high and where consent to different citizenship regimes and the frictions between them raise many questions about the possibility of conflicts flaring up, and in recent lived memory there have been violent conflicts, then problems of territorial differentiation, for example the Serbs in northern Kosovo, or the Kosovans at an earlier stage, or even other softer forms of regional differentiation, such as those in Croatia, in Istria, or in Vojvodina in Serbia, can raise claims that particular groups are receiving certain types of citizens are more equal than others, and that raises particular problems. There's also the tension between norms originating internally and norms originating externally, and this, as I said, has been a particular problem for the former Yugoslavia, and I've already written at some length on this in another paper, so I won't repeat that, but I feel that there are a whole range of different external norms impose themselves upon the former Yugoslavia, the states of Southeast Europe. They've voluntarily adopted and seek to enforce human rights and related norms. They've adopted conditionality. They are adopting conditionality in relation to EU accession and pre-accession processes, and it's hard to sustain these as to be characterised as entirely voluntary processes. But there's also been direct intervention by international organisations such as NATO and the UN and various agencies active in Bosnia and Herzegovina and Kosovo until recently. There's direct supervision by international organisations which persists, particularly for the latter two states. Other forms of international pressure, but also there is strong evidence of how the norms from other states, so sort of horizontal overlapping of those norms, is a particularly important form of external norm within the former Yugoslavia. Now, it's easy enough to just describe those, but then we have a whole range of law-type questions that need to be asked about those sorts of norms, like who made these norms? What's the legitimacy? What's the law-making process? What are the provisions to challenge such norms, or are they unchallengeable? Against what standard of legitimacy should we judge them? How are they given effect within domestic legal systems? And also, are there any judicial or similar types of processes which allow individuals or groups to challenge those sorts of norms? And there's a huge number of unanswered questions about those norms and their impact on citizenship regimes, which my mapping exercise and my analytical process of unpacking citizenship regimes hopefully will help to unpack. So I hope through that to have given you a snapshot of some of the questions that arise. I haven't particularly dealt with issues. There's so many other issues that could be dealt with. I haven't really talked about refugees or internally displaced people. I haven't talked about some of the issues that some of my colleagues are working on at the moment, such as sexual citizenship. I've just simply scraped across the top of the many issues that are raised around the Roma in former Yugoslavia and the way in which they interface with citizenship, and whether they can be regarded as somehow partial citizens in the context of these new states. So there are many other issues that I haven't touched upon, and I haven't either touched on the other side of the coin, which is citizens' activities, the activism of citizens in relation to the constitution of citizenship in the new states of Southeast Europe. Are there any examples of transformative constitution making in these new states to challenge some of the problematic politics, the problematic elite politics that have seen the concepts of citizenship being manipulated in such a way as to foster certain types of electoral advantage. So there is a huge number of issues that I haven't got time to go into, but I've just tried at the moment to sketch this on the surface. What I just want to do by way of a brief conclusion is to show that I think that this, in sum, this region represents a continuing good example of the Arendtian insight of the centrality of the right to have rights as constitutive of citizenship. Arendt shows us that when one is expelled from the polity, she's expelled from humanity, and thus without citizenship rights, there can be no realization of human rights. So, in that sense, the paper presses the case for the starting point of citizenship as legal status. So I'm not trying to abandon the formal concepts of law and citizenship, I'm trying to go beyond them. But as I said in my lecture, law has traditionally had a rather constrained role in helping us to understand a concept of citizenship which stretches beyond the legal core of membership. Who is or is not a member of a given polity? What legal rights and obligations do they have? I would argue that citizenship nested in the midst of a network of norms is a very useful way of going beyond the politics of membership, giving some content and specificity to the task of studying citizenship, which otherwise risks becoming excessively broad and vague from my legal perspective. The point about the space of law approach is that it provides a useful metaphor, or space, to enclose the multiple contestations of normative order that are so important to understanding both individual citizenship regimes, but most particularly those regimes as a group, and not an isolated group, but a group of uniquely closely interconnected regimes which themselves are interconnected in different ways with other regimes in the region. Those further afield through diasporas and immigrants, and those other regimes interconnected through the EU. So it offers an alternative to another useful metaphor which Rainer Bauberg has elaborated, the concept of citizenship constellations, which is used to grasp something about the multi-perspectival interconnectedness of citizenship regimes. And to my mind, it offers something beyond a body of citizenship scholarship which takes one perspective or another, whether that's nationalist politics, transnational relations, diaspora politics, consequences of immigration or treatment of immigrations, and treats that as constitutive of the essence of membership and ignores the other dimensions. The interconnectedness is not just at the systemic or institutional level in the context of the systems and norms themselves, but also in the way that individuals and groups negotiate their way through the labyrinth of tunnels offered by these systemic or institutional connections. And I appreciate I've said very little about that today. That's still to be developed. The choices that they make is individual and group level. The space of law idea reinforces the multiple roles of legal institutions and norms, and brings law back in a way that goes beyond the role of citizenship law, limited to rules governing acquisition and loss. It engages equally with non-citizenship or quasi-citizenship or partial citizenship. It captures the role of law in relation to the claims and institutions of active citizenship. It recovers something about law in the relationship which does not appear in most theories or conceptualizations, in that law is not relegated to being just a boundary marker or merely an instrument for upholding or undermining certain social choices made elsewhere, or of being simply a means of solving problems which arise in the international sphere, such as statelessness. It encompasses, in that sense, both the abnormal and the normal and exceptional incidents of citizenship or its absence. Thank you very much.